Hey, Brian Parker here with another exciting video on an oldie but a goodie. Spasms would describe how I see certain debt collectors or creditors suddenly start up where there's tons of a certain kind of lawsuit. And lately it's been velocity investments. I don't know what anybody's investing in, but it's not publicly traded or anything like that. But anyway, it's not even the real name of Velocity if you check it out. Anyway, and you can see that in what I'm going to show you later on in this video. I am doing a Velocity Investments, LLC 2.0. I've done one of these before. I think I touted the top 5 ways to take out Velocity. This will be sort of that, but I'm going to supplement and include what I've since learned, and you learn constantly by suing and answering and kind of Sherlock Holmesing your way through things to figure out how to get to points. And that's the name of this video today. The top 3 trigger points to beat velocity. And later on this video, I'll give you 3 surefire trigger points that I have learned in my practice that when I do it, case goes away. So it is all about trigger points in my business because as you know something, you get better at figuring it out. I quoted this, I think it's, I don't even know the guy's name. It's some philosopher that says, know yourself, but know your enemy better. So after 30 years of doing this, I know them all. I know the trigger points. I know the ways that they try to screw people over, and I can head them off at the point. But again, if you stay tuned with this video and I don't bore the heck out of you, I'll give you 3 trigger points, which are surefire winners, at least in my experience. It all starts from the bill of sale. So in a Velocity Investments lawsuit, there'll be 3 things attached to a lawsuit: the bill of sale, certificate of loan sale, and an affidavit from normally from New Jersey. And again, it's from someone from Velocity Investments saying, yep, we own it because we said we do. And by the way, I've deposed that person and she doesn't even work for Velocity. It turns out Velocity is just sort of a front, is the best way to put it. Gonna put a lot on the web membership website with this video today. And that's what I'm talking about as far as updating. I'm putting the transcript of my deposing an affiant from Velocity. I'm putting an answer, a counterclaim. That's right, counterclaim. That's one of the triggers I'm going to tell you about. The counter affidavit, all in Word, all examples for you to use. Velocity generally follows the same technique as I said. Bill of sale, certificate of loan, and the affidavit. They'll attach maybe a letter or 2 saying, hey, we're Velocity, we own your debt now, without saying who they got it from. Once in a while, a debt collector letter will show up from them where they name this weird sounding trust. It's rare, but I see it. And that's part of the bill of sale that we're looking at right now. I'm going to put one up for you. Shazam. And you know what? Let me put up 2. Shazamski. So you got 2 bill of sales. This is your basic bill of sale. So the first one, and again, like all bill of sales, here's a pro tip. They all are based upon a forward flow agreement. So whoever's the buyer is and the seller, it'll say, for value received and pursuant to the terms and conditions of the purchase and sale agreement. That's a forward flow agreement that all debt buyers buy and sell through. So this is a mini trigger point. I'll give you this now. Do discovery, and you will ask for that, and you will see rockets and bullets and craziness trying to stop you. It's their trade secrets. Your argument to that is, then why is it in the bill of sale that you're claiming is the reason why you own the debt if you don't want people to see it? You can't have it both ways. It says pursuant to the conditions. So, I'm also going to throw in on this an actual deposition. I'll send you 2. I'll give you 2 deposition notices on this membership website. in Word. Also, discovery of velocity in Word, so you can conform it. It's all the same, but you can conform it to your facts and state law. I'm not telling you how to practice your law or your life. So those two bill of sales are basically the same. You can see there's some weird, I call it weird, but it's weird. In one, it's called Upstate Funding Grant to Trust. Another is called Upstate Funding Grant to Trust 2019 versus 2021-3. So, and they will say this gives Velocity Investments all rights, title, and interest to those certain charge-off loans and all related receivables without telling you your or your clients. So they'll add like a list of account numbers and a purchase price, which you won't see the purchase price, and say, see, that debt is ours and yours, and now you owe us, which does neither. So you've got those two bill of sales. It's incredible what they think proves they own the debt. First of all, let's put those two back up, Shazamski, and look at what's happening here. They're claiming this weird sounding trust, Upstart Funding Grant to Trust, either way, in either picture, is sending everything to Velocity Investments. So let's focus on that first one, 3/24/2022. All right. And by the way, with that still up, Upstart Network Inc. is called the initial seller and servicer on behalf of Upstart Funding, blah, blah, blah. Yet Upstart Funding Grantor is the initial seller and on behalf of additional sellers. Well, the initial seller is the actual bank that you got the loan from, which is usually Cross River Bank, Blue Ridge River Bank, something like that. There are all these banks that are the initial sellers. They are the original creditor. So this grantor trust cannot be an initial seller. So that's already false. I've done a deposition of someone that claims to know the ins and outs of the bill of sale, and they admitted under oath that this is wrong. There's some semantic language that bothers them. So this is a whole plate of wrong, and I'm going to show you why. 3/24/2022 is when Sanjay Datta supposedly signs. Remember that name. He's claimed to be a CEO, without saying a CEO of whom, a CFO, but he works for Upstate Network. He may be the original owner of it, but they don't like original owners, so I'm not going to say anything about that. They all these bill of sales, the first thing that is attached to the lawsuits, are all secured trusts. They're special vehicles where after you get the debt from them, it's originated, within a week it's placed in these secured trusts. And then a bunch of trusts get involved and have a feeding frenzy on your debt. Velocity, again, in their lawsuit, and let me put up an average Velocity lawsuit, Shazam, and that is going to say 6, defendant account with Cross River Bank was serviced by Upstart. So far, so good. Cross River Bank subsequently assigned all rights, title, and interest in that account to Upstart Network. So that's the second sheet I was telling you about, the certificate of loan sale, which is attached to Exhibit A. And then it says the Upstart Network, pursuant to the bill of sale, subsequently assigned the defendant's account to plaintiff. So what we need now is an Upstart assignment to plaintiff, which is Velocity. So we will look at the certificate of sale, and it has the words no assignment of Velocity on it, Shazam, and that's your certificate of sale. They claim it is, but they never title it, but they claim that's what it is. And you can see sort of that the transferor, which is Cross River Bank, is assigning to the transferee all loans identified at attachment A. I assume that includes somebody's loan. You'll notice that as I've written the words, there's no assignment to Velocity. Yet, did their lawsuit not just say the Upstart network pursuant to the bill of sale subsequently assigned the defendant's account to plaintiff. And that is supposedly done on 3/30/2022. So remember that bill of sale, 3/24, with everything, the right, title, and interest. Let's put the bill of sale up with the 3/24/2022 date on, Shazam. And let's put the certified, what they call the certificate of loan sale, next to it with the words no assignment to velocity, Shazam. See, the date of 3/30 is when Cross River Bank is supposedly sending debts, yours maybe, to the transferee, which in this case is Upstart. That's what they're referring to as proves that Velocity owns the debt. There's no assignment to Velocity in that paperwork. However, look at the date of the bill of sale. It's 3/24, 6 days earlier. Now, this is a common theme. I'm using this by example of most Velocity lawsuits. They're claiming that the Upstart Trust, it was 2019, 2020, 21, whatever it is, has assigned the debt to Velocity in the bill of sale 6 days before Cross River gives the same debt to Upstart. How is that possible? If Velocity gets a debt, it somehow still exists for Cross River to give to Upstart 6 days later, after the debt's already been supposedly all rights, I'll use their words, all rights, title, and interest were already given to Velocity 6 days earlier. And again, the lawsuit points to the certificate of sale, which is on the 30th, as the thing that gives it to Velocity when it doesn't. I'm using their words, their pleadings, and that's their proof or lack thereof. Here's the thing I forgot to tell you. See the bill of sale, the one with 3/24/22? It says Upstart Grantor Trust is giving all this stuff, let's say Velocity. We'll give them that. We'll just pretend. Who gave it to Upstart? Think about what I just said. You didn't get this loan, debtor, me, whoever it is. You got it from, in this case, Cross River. You didn't get it from Upstart Funding Grantor Trust for it to be able to send the right, title, and interest in those certain charge-off loans and or retained receivables. So who gave it to Upstart Funding Trust, right? They can't give what they don't have, yet you will never see that assignment. And again, they're doing this 6 days before Cross River claims to still hold the debt to give it to Upstart. It's a convoluted mess. So what do you do with that mess? In this case, I'm going to give you 2 floating videos, or a couple. Check out all my videos. I want to go, is it that way or that way? All my videos on how to defend against a collection lawsuit, how to handle, what to do, and how to create the ASS. What is that? No, it's the account stated statute. You got to create that counter affidavit. So there's a couple of videos there. But I give you a free, if you go to my membership website, there's a free PDF checklist. And there it is, floating by. And that is free. Just go to my membership website and you get a whole checklist on how to answer these lawsuits. These are all pretty much the same as far as debt buyer lawsuits. So I've attached a ton of stuff to this video. I want to now talk about the affidavit. Let's put an affidavit up here, Shazam, and that's your average affidavit that you receive in a Velocity lawsuit. And focus on number 3, that plaintiff's predecessor in interest sold and assigned all right, title, and interest. We heard that before, to the defendant's Cross River Bank account to the plaintiff. That has to be explained greater than predecessor in interest and stumbled over. Where is the trust they were talking about? Where is Upstart? How did Upstart get it? There's got to be a recognition of the very thing that's in your lawsuit and in your paperwork. But that subtlety and nuance following the law seems to evade the affiant here, as does the fact that she's referring to velocity and as a plaintiff and my client as a defendant weeks and months before the lawsuit's even filed. So she's signing under oath, this is true. Now, I've deposed this specific Miss Rivera, who's on most of the lawsuits that I see, as backing up and supporting the lawsuits that go against anybody with a velocity case. And she admits, and boy, it was like a deer in the headlights. When I'd ask her specific questions about her own affidavit, deer in the headlights. We both the attorney and I had to go, like, hello? She finally admitted, no, I did not create this. I have no idea what's going on. And I'll give you an example. Here's a snippet. Just to reiterate what you said before, Ms. Rivera, you've not seen an assignment or transfer of any kind to Upstart Funding Grant or Trust. Is that correct? So that's what I was telling you about. In the bill of sale, Upstart Grant or Trust, or whatever weird trust sounding trust, is giving it all to Velocity. But who gave it to them? And so she'll say, correct, because she's not seeing that assignment, even though she wrote that thing that predecessor and interest gave the debt to plaintiff. And then I say, all right, just for the record, Shazam. All right, just for the record, the bill of sale was in this case, 5/26/2020, approximately 2 months before what you call the web certification. Is that correct? Yes. So you know what a chain of title is? Yes. Would you agree there's a missing link here? No fault of your own. You give them, when you depose someone, you got to be gentle and kind of blame someone else to get the admission, depending on how you perceive it. And I'll be doing another video on deposition. So she says, missing, yes. So would you agree that there's a missing link here? No fault of your own? Missing, yes. So your case is done there. She's already admitted, unless Velocity can rehab her. They didn't. They don't want to. I don't think they asked her any questions. Or you get a crazy judge that overlooks something in writing. And that happens. So I also, within the loan agreement, that's another document to be attached. Will be, of course, I've talked about this many times, the governing law provision. So you're being sued usually for breach of contract, account stated, and sometimes unjust enrichment. They're claiming you breached the contract and you didn't pay. That's fine, but the governing law provision in the actual contract they claim you breached will require you to follow federal law or the law of New Jersey or the law of Utah. It's usually those two states. Yet they're suing you in Wyoming or Michigan or Florida or Georgia. So they don't have clean hands. They are violating the own contract they seek to uphold by pointing the finger at you. They are not a member of the Clean Hands Club. So it's time. It's time for the 3 triggers now that will win you this lawsuit. I want to point out something before I do that. One of the triggers is based upon the discovery I do of Velocity, just to bring to the forefront what they are missing, because they pretend like they don't understand what I'm saying. And the reason, again, as I've said, when you ask discovery questions, hills that you're prepared to die on, meaning limit your questions to important things the judge won't yawn because she's looking at 50 interrogatories. So you ask him let's see if I ask the right question. Number 7, the Upstart network subsequently assigned the defense account to plaintiff Velocity in your complaint number 7. Please state what document specifically states Upstart network assigned the defendant's account to plaintiff Velocity and the date it was signed and by whom. So you heard me talk about that, what was missing. That goes in your discovery question. I will put discovery questions in Word for you on the membership website. So I want to tell you, as we get to the triggers, it's important you know this background. So let me put this up. I'm going to put this up. Starting interrogatory number 2 and you'll see request for production number 3. Shazam. So the reason I put that up is their response. The last sentence of the first paragraph, plaintiff further objects to this interrogatory because it's directed to non-parties. So what they do when they say that, and if you look at request for production number 3, again, second from last paragraph, the last sentence in the paragraph, plaintiff further objects as the request for production because it's directed to non-parties. So what are they saying? It's important. The non-party is Upstart. So they say they own a debt from Upstart, and Upstart gave it to them with no proof. So then you go, well, give me the proof from Upstart. They go, oh, it's not out. They've got it. See how that is? We're not going to prove it. And when you ask for the thing we say it's based upon, we don't have it. It's with a non-party. So what do? What I did is I filed a motion to compel to depose this Mr. Data, Sanjay Data. Turns out he's this rich guy in charge of Upstart Network and doesn't like to be deposed. I got this small court. I talked about this in another vehicle based upon a motion to compel. All I'm saying is you're saying this, so back it up. And you know that's going to go to a motion to compel, and it's going to serve you well. So on my website, again, I'll do the actual motion to compel. You may need it. I hope you do. See my discovery against this Velocity in Word again. And then here's the fun thing. It's a court order. I'm not going to put it up, but it's a court order attached to the website, the membership website, collectionstoppersolutions.com, showing you the actual order. It was great. It's like this little court says to this bigwig out in California that thinks he's evading responsibility for the thing that made him tons of money at other people's grief, and frankly, misrepresentation. So all you got to do is give me the paperwork. I guess you could say Velocity's making the misrepresentations. Okay, I'll go with that. But you know what you're doing when you're signing this stuff and tranching it into securitization and not providing the proper proof to the company you supposedly sell this debt to. Where is all that information I just said right there about what are the duties of a seller to a buyer, a debt buyer? Guess what? All that stuff, all the warranties, the representations, how much will be given to the debt buyer Velocity by Upstart is in what? It's in the forward flow agreement. Everything. That's why they don't want you to see that, because a lot of it is like, okay, we're giving you this stuff. Oops, sorry. But that's on you, buddy. This is sending to you without recourse. So they don't want that out in the public realm that the person they bought the debt from says, we really don't represent this is safe, or we're not going to warranty this. It's as is. It has no brakes. Cars, we don't care. You take it. They don't want that out there. So I want that. You should want that to get this case settled. It's not one of the triggers, by the way. You've done your creative counter affidavit based on what? What's it based on? Hello? Hello? That's right. You got it right again. Every time you get it right, using their own documents against them. So, time for those trigger points. These are trigger points based upon my knowledge of suing these guys, debt buyers in general. But it's true. Each company has their own uniqueness. So what works with one doesn't work with another. Some are good to deal with and are cool. Some are total jerks. I find, by the way, there's an expression, the apple doesn't fall far from the tree, or the acorn doesn't fall. And their attorneys are generally the personality types of the company they service. So if my first contact with Velocity, for example, other than the lawsuit, is the attorney is a real jerk, now I go, okay, it's going to take a little bit. I've got to step harder. And so how I step is actually, there was this martial arts trick. And, you work on martial arts, you work on your body, you twist and turn. But one of the strongest things you do would be a room clear. And let's say across the room, your kid is in danger, and you're way across the room, and all these people are in your way. You use what's called a room clearer, and it's just 2 fingers, man. And when we practice this in my class, we didn't hold back. So by the end of the class, you're like, yeah, you're talking because you're forcing your fingers and getting stronger each time. And the guy in charge did not want you holding back. He just hoped that nobody get killed. So what you do, you got to get to your kid. He's in danger, and there's all these people around. You use I read harder to wrap this up. The room clear, and all it is you go right into the throat, and they go down right fast. Boom, 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 boom. Kid is safe. So here are the 3 room clearers. The trigger points. It's just a trigger right there. That even hurts. Number 1, they do not like to be sued. So you do a counterclaim. Simple as that. They do not like counterclaims. I literally filed a counterclaim on Friday, and apparently I got a call that day. I was out. That said, okay, we want to settle. Now, the thing that bothers me about that is I just spent all that time and energy on a case that's at least 2 months old. You could have settled prior to that. And the attorney acts like, you know what, they've had to change their heart. And it wouldn't have happened but for my counterclaim. So that to me is a trigger point. Sue Velocity in a counterclaim. I will attach on my membership website, collectionstoppersolutions.com, an answer, a counter affidavit, and the counterclaim. They're all based on your well-crafted counter affidavit, all in Word for you, all right? Number 2 trigger point, room clear. Seek to depose the affiant who claims to know details of the lawsuit. I always try to think a couple of cases ahead, really. So I'm not only deposing the affiant for this case, but anything she says that helps me in future cases, you'll see it. And you'll see it here. I'm going to add the actual transcript of an affiant, someone that signs the affidavit for Velocity, and she shows up in lots of cases. So you can just take a piece and go, that's funny because she said, boom. And you do that. That's an admission against, it's called, I don't know the proper context, it's called an admission of a party opponent. And that's usually in trial work, it's overcoming objections of hearsay. But it's an admission nonetheless in whatever context you want to use it. And usually in pre-trial motions and things like that, you can use it without exception. So use the deposition approach as a trigger point. And I will put on my membership website 2 deposition notices for you to use if you want using your law. Number 3, go after this guy, Sanjay Datta. He's signing all these things that are questionable. And as I said, I recently had a case where I chased him, and suddenly he was no longer a non-party to the Velocity attorney who previously was like, that's Upstart, it's got nothing to do with us. The Velocity attorney now is negotiating with me. And I'm like, how are you representing them? I thought they were non-parties. So, it's all BS. So make sure you go after that non-party. Really, it's a lot of fun, and it's a trigger point. So this whole thing really is about trigger points. But again, what's my number 1 rule? You got it. You're too good for me. It's use their own documents against them. I think it's 90%. Before in the video, I said 80% of this is their documents. In a Velocity case, their documents are almost 100%, and their lawsuit, as I just showed you, just kills them. I don't understand why they do that, other than the concept of 90% of these cases are going to settle. The Velocity attorney said to me many times, why don't you leave us alone? What, leave you alone to get 100% default against people? I wish I could take every Velocity case just to sue these guys, because they are blinded to right and wrong. It's just they believe they are debtors, therefore they owe us. And we're going to bring schlocky paperwork on hope that we can bully you into a default or a settlement. And they will without an attorney. Or you. an educated debtor that's used my membership website, and you use these trigger points. Okay, like, love, subscribe, be good to each other, be bad to velocity. Use these trigger points. Use the throat clearer. All right? I thank you for listening and watching. Brian Parker out.